Virtual idols, copyright, and the law, China's legal experiments and what Australia might learn. In reduction, welcome back to China Australia Topic Podcast. Today, we're stepping into a legal grey zone where technology, culture, capital, and creativity collide, the world of virtual idols, and the legal struggle to define who owns them. Our discussion is based on a 2026 peer-reviewed Chinese legal article.
虚拟偶像著作权保护困境破解研究
Research on resolving the dilemmas of copyright protection for virtual idols by
傅义桥
Fuyukiyo An,
刘备
Liu Bei, published in Open Journal of Legal Science December 2025. This article tackles an important contemporary question. When an idol isn't human, who owns its face, voice, personality, and performance? This matters deeply in China, where the virtual idol market is exploding. It also matters in Australia, where AI-generated performers, synthetic voices, and digital avatars are rapidly entering entertainment, advertising, and education, often ahead of the law. Today's key Chinese legal concepts include
著作权
copyright,
作品
a protected work,
虚拟偶像
virtual idol. These are not just technical terms. They shape who profits, who controls culture, and whose creativity counts. Let's begin by understanding what virtual idols actually are, legally, culturally, and economically. Section 1, Legal and Social Background. 1. What is a virtual idol? There is no unified legal definition in China, or anywhere else for that matter. The article surveys several views before offering a working definition.
虚拟偶像通过电脑图形化等技术制作的虚拟人物形象，在外形、声音和表演中凝聚人类创作，用以满足情感投射需求。
In English, a virtual idol is a digitally created character, often a singer, streamer, or performer, whose appearance, voice, and performance embed human creativity, designed to receive emotional investment from audiences. Think of
洛天依 初音未来
Hatsune Miku, or China's ASOL Group. These are not simple animations. They are IP, intellectual property, assets, brands, emotional objects, long-term commercial platforms. 2. Market context. Why the law is under pressure. According to cited industry reports, 2024, 27 yen billion RMB in direct revenue. 2025, virtual human core market nearing 480 yen billion RMB. 2031, projected 120 yen billion RMB in idol-specific revenue. The law, however, is still built around books, paintings, films, and songs created by humans. This mismatch creates what the authors call
著作权保护困境
a copyright protection dilemma. 3. Chinese copyright law framework. China's copyright law
著作权法
protects, works with
独创性
originality expressed in a
一定形式
fixed form. Article 3 lists categories: literary, artistic, audiovisual, plus a catch-all clause.
符合作品特征的其他智力成果
Other intellectual achievements meeting the characteristics of a work. This clause is powerful, but unhelpfully vague, and virtual idols don't fit neatly into any single category. Section 2, Core Legal Analysis. 1. The first dilemma. What kind of work is a virtual idol? Courts have tried different approaches, treating the idol as a visual artwork, protecting the name under trademark law, treating performances as audiovisual works, sometimes invoking unfair competition law. The result:
同案不同判
similar cases, different outcomes. This legal fragmentation creates uncertainty for creators, investors, and platforms. 2. The article's key proposal: disaggregate and layer. The authors reject treating a virtual idol as a single object. Instead, they propose
拆解加分层保护路径
disaggregation plus layered protection. Let's break that down. 3. Appearance.
美术作品
A virtual idol's visual model, 2D or 3D, is designed with line, color, proportion, expresses aesthetic judgment fixed in digital form. Therefore, it fits squarely within artistic works. This aligns closely with Australian copyright law, where 3D digital characters can qualify as artistic works. The originality threshold is similarly low but meaningful. 4. Voice. The most radical proposal here. The article makes its boldest move. 2 categories: 1.
真人驱动型虚拟偶像，
Human-operated virtual idols. The voice belongs to the
中之人。
hidden performer. Protection path.
民法典第1023条，
Voice treated as a personality right, like likeness comparable to Australia's passing off and emerging voice misappropriation debates.
2. 算法驱动型虚拟偶像，
Algorithm-driven idols here. Voices are synthesized, built from real voice samples, heavily edited and recomposed. They are not natural human voices, yet deeply creative. The authors propose a new legal category.
合成声纹作品，
Synthetic voice print works. This does not yet exist in Chinese law, but arguably should. Australia currently lacks an equivalent category, making this proposal globally significant. 5. Persona and narrative copyright plus unfair competition. A virtual idols.
人设、
Character design, personality, backstory. Traits may be a literary work, a visual narrative, or protected via
反不正当竞争法，
anti-unfair competition law. This hybrid approach mirrors how character copyright functions in common law systems. 6. The second dilemma: who owns the rights? This is the hardest question. A virtual idol typically involves designers, programmers, voice actors, investors, operators. The article rejects treating them as
合作作品，
joint works. Why? Because joint ownership fragments rights and kills commercial viability. 7. The author's solution: ownership follows investment. The proposed rule:
法人作品，
owned by the investor,
职务作品，
owned by the employer, creators protected via mandatory benefit sharing. This prioritizes economic coordination, not romantic authorship. Australia, by contrast, still places heavy emphasis on individual creators. Their work-for-hire arrangements quietly dominate in practice. Section 3: Challenges and Reform Directions. 1. The problem of over-contractualization. China currently relies too much on contracts. The article warns off bargaining power imbalance, rights fragmentation, future licensing deadlocks. This critique applies equally to Australia's gig-based creative economy. 2. The performers' rights problem. For
中之人，
performers, the authors propose
法定让渡原则，
statutory assignment principle. If contracts are silent, certain performer rights automatically transfer, but additional compensation is mandatory. This is more protective than Australian performer regimes, and arguably more realistic. 3. A metaphor. Think of a virtual idol as a digital orchestra. Many musicians contribute, but the symphony needs one conductor. Legally speaking, fragmented ownership leads to silence. Section 4: Key legal vocabulary and reflection. Let's recap 5 core terms.
虚拟偶像，
Virtual idol, a composite digital performer.
著作权，
Copyright, economic and moral rights over works.
作品，
A protected intellectual work.
合成声纹作品，
Proposed category for AI-generated voices.
法人作品，
Employer-owned works created under organizational control. Reflection questions. Should law prioritize creativity or coordination? Can personality exist without a person? Who should benefit most from digital labor? Conclusion to Part 1: China's approach to virtual idols shows a legal system experimenting in real time, not by phrasing innovation but by re-engineering categories. Australia will soon face the same questions. And when it does, China's experience may prove less foreign than we expect. Part 2: Australia's legal system. To this point, we have explored how Chinese legal scholars and courts are grappling with the copyright dilemmas posed by
虚拟偶像，
virtual idols, digital performers composed of appearance, voice, persona, and performance. We saw how Chinese law is experimenting, sometimes boldly, with
拆解式保护，
disassembly protection, breaking a virtual idol into legal components, and even proposing new categories such as
合成声纹作品，
synthetic voice print works. Now we turn the lens around. What happens if we ask the same questions about ownership, originality, performance, and personality inside the Australian legal system? Australia does not have virtual idol law, but it does have copyright doctrine, case law, and institutional instincts that quietly answer many of the same problems, often in very different ways. Let's begin with first principles. Section 1: Australian Copyright Foundations. 1. The statutory framework. Australian copyright is governed by the Copyright Act 1968. Commonwealth. At its core, copyright protects original works created by human authors expressed in material form already, we see tension. Virtual idols are composite, collaborative, often partially or wholly machine-generated. Australia has no catch-all clause equivalent to China's.
符合作品特征的其他智力成果
Other intellectual achievements that meet the characteristics of a work. Instead, Australian law is category-driven and author-centric. 2. Originality. The ICE-TV principle. The High Court of Australia's decision in ICE-TV Pty Limited versus Nine Network, 2009, is foundational. The court held, originality requires independent intellectual effort, not novelty. This matters for virtual idols because a 3D model can easily satisfy originality. A voice synthesis pipeline may or may not. A persona may be too abstract unless concretely expressed. Australia asks not is this innovative, but where is the human intellectual effort? Copyright in a compilation protects only the author's original expression, not the underlying facts or information, and originality requires independent intellectual effort, not mere labor or industry. This contrasts sharply with China's growing willingness to attribute creativity to complex technical processes. Section 2 Virtual Idol Appearance and Character Design 1. Digital characters as artistic works. Under Australian law, a virtual idol's visual form would likely qualify as an artistic work, drawing, sculpture, or computer-generated image. Key cases include Burke vs. Spicer, 1938, Chapter 400. Originality in visual design. Copyright subsists in an artistic work where the work originates from the author and is not copied, even if the subject matter itself is commonplace or derived from nature. Originality requires independent creation, not novelty or artistic merit. ACOS Pty Limited vs. UCorp Pty Limited 2012, FCAFC 16, Protection of Structured Digital Content. Copyright does not subsist in information, facts, or data generated or structured by a system, unless the form of expression reflects human authorship, involving independent intellectual effort. A computer-generated compilation without such human authorship is not protected as an original literary work. There is little controversy here. Like China, Australia is comfortable protecting appearance, but, and this is crucial, ownership follows authorship unless displaced. 2. Ownership. The work for hire illusion. Unlike the US, Australia has no explicit work for hire doctrine. Instead, employer owns copyright. Section 35, 6. Contractor's creator owns copyright unless assigned. This creates risk for virtual idol projects involving freelance designers, motion capture performers, voice actors, AI engineers. China's proposal, defaulting ownership to investors via
法人作品、职务作品
works created by legal entities / works made in the course of employment, is far more centralizing. Australia's approach is more liberal but also more fragile. 3. Character protection limits. Australian courts are cautious with character copyright. A character must be clearly delineated, consistently expressed, not merely a general idea. This raises problems for virtual idols, whose persona evolves dynamically, especially through algorithmic interaction. China's willingness to supplement copyright with
反不正当竞争法
anti-unfair competition law has no direct Australian equivalent. Section 3 Voice, performance, and the missing right. This is where the comparison becomes most revealing. 1. Voice as property. Australia says mostly no. Australia does not recognize a freestanding personality right over voice. Instead, protection is fragmented, passing off misleading or deceptive conduct. ACL, Australian consumer law, occasionally copyright in sound recordings. Cases such as Henderson versus Radio Corporation Pty Limited 1960, State Reports, NSW 576, and later endorsement cases protect commercial reputation, not voice identity itself. In an action for passing off, a plaintiff may succeed where the defendant's use of the plaintiff's image or reputation in connection with the sale of goods or services falsely suggests an endorsement or commercial association. Even if the plaintiff and defendant are not in the same field of business, the crucial question is whether the misrepresentation is likely to lead the relevant class of purchasers to believe that the plaintiff has approved, endorsed, or is otherwise commercially connected with the product such that the plaintiff's reputation or goodwill is appropriated to the defendant's advantage. By contrast, China explicitly treats voice as part of
人格权
personality rights under the Civil Code. 2. Performers' rights. Part 11A Australia does recognise performers' rights, including control over recordings, moral rights, attribution, integrity, but these rights are limited in scope, easily assigned, poorly adapted to virtual or synthetic performance. A
中之人
performer in Australia would almost certainly be required to assign rights contractual, with no statutory fallback compensation mechanism, unlike the Chinese proposal of
法定让渡原则
the principle of statutory transfer. 3. Synthetic voices. A legal vacuum. Australia has no category equivalent to
合成声纹作品
synthetic voice print works. A synthetic voice may fall into sound recording copyright, if fixed, or nothing at all critically, if the voice is AI generated. The contribution of a human voice actor is indirect. The final output is generated dynamically, then authorship collapses. This creates what we might call a rights evaporation problem. China's proposed solution, creating a new work category, is far more systematic. 4. Hypothetical scenario. Imagine an Australian company creates a virtual influencer. The voice is trained on a voice actor. The model later generates new speech autonomously. Questions Australian law struggles to answer. Who is the author? Is there a work? Can there be infringement without authorship? China, by contrast, is actively designing answers, even if imperfect. Section 4. Contract, fragmentation, and transaction costs. 1. Australia's contract dependence. Australia relies heavily on copyright assignments, licensing chains, moral rights consents. This works until technology evolves faster than contracts. China's article identifies 3 risks that apply equally to Australia: bargaining imbalance, rights fragmentation, future use deadlock. The difference is that China is willing to legislate its way out. Australia is not, at least not yet. 2. Market efficiency versus author protection. Australia traditionally emphasizes individual creators' moral rights, authorial dignity. China's proposal prioritizes capital coordination, market scalability, centralized rights ownership. Neither approach is morally neutral, but for virtual idols, the Chinese model may simply be more functional. Section 5. Comparative reflection. Let's place the systems side by side. Issue: visual design China, copyright Australia, copyright. Issue: voice China, personality rights plus proposal Australia, fragmented stroke weak. Issue: synthetic voice China, proposed new category Australia, legal vacuum. Issue: ownership China, investor-centered Australia, creator-centered. Issue: performer protection China, statutory fallback Australia, contract only. Issue: flexibility China, high Australia, low. China is engineering law forward. Australia is waiting for disputes. Conclusion to Part 2. Virtual idols expose something deeper than IP, intellectual property. They force legal systems to answer: is law protecting creativity or coordination? China is openly experimenting, accepting doctrinal risk in exchange for industrial clarity. Australia remains cautious, principled, but increasingly inflexible and brittle. As AI-generated performers become normal rather than novel, this divergence will matter.
法律之桥连接世界
The bridge of law connects our worlds. Stay connected.